Excited to have you all here today. Welcome to Travel, Recreation, Wildlife, and Cultural Resources, the Senate Committee, which is obviously one of the better committees you've probably been to, I'm guessing, right? And we're always happy, and I don't know if you noticed, we're a little bit color coordinated, other than Senator Ellis didn't get the memo about the pink, but we have to have some red to balance out the pink. So anyway, happy Valentine's Day, everyone. We're excited to see Representative Larson here today and Kit Wetland from the governor's office. We are excited, and you and I have a beautiful red tie as well. So we're going to, first bill up today will be House Bill 83, Tribal Agreements to Hunt and Fish. And with that, we'll go ahead and let Representative Larson kick us off.
Thank you, Madam Chairman, and I wished it was my intent this morning that I had my mind focused on Valentine's Day and chose this tie, but we all know better. But even a blind sow gets an acorn once in a while, right? Madam Chairman, House Bill 83 off-reservation hunting is an interim conversation that's taken place between the Eastern Shoshone Tribe and the governor's office. And before I get into the bill, I think it's important that the committee have a little historical background for the intent of the bill and why we have it before you. So in 2014, Clavin Herrera was an enrolled member of the Crow Tribe in Montana, and two other tribal members crossed over into Wyoming, killed 3 elk. Wyoming Game and Fish charged him and them with misdemeanor crimes for unlicensed and out-of-season hunting. He was convicted in state court. Herrera claimed he was granted rights to hunt there as a member of the Crow Tribe's right to hunt on unoccupied lands in the tribe's 1868 Fort Laramie Treaty. Okay, so then the state claimed, based on an 1896 Supreme Court ruling on a Wyoming case, Ward v. Racehorse, where a Shoshone-Bannock member who has a similar treaty had shot elk in southwestern Wyoming and was arrested, that went to the Supreme Court, and the Supreme Court's decision was that the statehood had abrogated the tribe's off-reservation hunting rights. And that Supreme Court ruling had been the law of the land since that time. The Herrera case was then appealed. He continued to appeal it to the Supreme Court. In May of 2019, the Supreme Court overturned the lower court Herrera decision and said that the Supreme Court found no evidence that the statehood abrogated the treaty rights of Indian tribes to hunt off-reservation lands. This decision has set aside the state law based on the Racehorse 1896 decision, which again had been, to this point, had been the law of the land. Similar to the 1868 Treaty of Fort Laramie that the Crows based their right to hunt on, the 1868 Fort Bridger Treaty in Uintah County is where the Eastern Shoshone is the tribe that the Eastern Shoshone and the Shoshone-Bannock have, which has the same language as the Crow Tribe's treaty, allowing hunting on unoccupied lands outside the reservations. So the Herrera decision has left some ambiguity on the state's right to manage wildlife and as well in conservation, and as well tribal treaty rights to hunt off reservation. So in May of this last year, the Eastern Shoshone Tribe approached the governor's office and suggested the tribe and the state work together to define and establish a process to respect the conservation efforts of both the tribe and the state while addressing the hunting rights of the tribe with the right the state has to manage wildlife. Some complex issues there. The result of that collaboration between the state and the tribe, along with tribal Fish and Game and Wyoming Game and Fish, is House Bill 83. And in essence, in 83, what we're doing is we are giving the governor authority to negotiate off-reservation hunting agreements with recognized Indian tribes to codify their hunting, fishing, trapping, and gathering rights. In granting this authority, we put establish guidelines based on current and best wildlife management practices, and is a much more responsible way to make sure we all have good regulatory structure in place, so that we don't need to wait for someone else to be a test case, or wait for the court to determine how the process should work. So as we go into the bill, I'm going to, I think it's important for us to, again, as this come over from the House side, we had the Eastern Shoshone Tribe. This bill was heard in the Appropriations Committee, and the Eastern Shoshone Tribe came and testified, and there was some consideration of some amendments at that time. They strongly suggested that we not amend the bill because of the time that an effort put into it, and that it would be difficult to support the bill if we amended it in any way, so we didn't. So we passed the bill through the House. Since that time, the Eastern Shoshone Tribe has come out and said they no longer support the bill for a variety of reasons that we'll leave for their testimony. As we consider this today, I think there's a couple of important elements out there. Conservation, management of wildlife, states' rights, and treaty rights. And I think there's room in our world for all of the above, and we need to do that. The tribes, historically as sovereigns, prefer to deal with the sovereignness of the state, and like to do that with the governor's office. So allowing the governor to have some authority to have those conversations, I think, is an important component, or something that we need to have in place. We as the legislature like to have our say in it, and we like to say yay or nay on any of this. So however this shakes out, I think that we need to define, at least give the governor some parameters that he knows that he won't come back and have his hand slapped because we didn't like what he did to begin with. And so it'll be an interesting conversation today, and as you guys consider it in committee of the whole. But as I understand the process from my time being in the legislature, our role today is to bring you the bill as it came over from the House, explain the process, how it came here, listen to the public comment, and move forward from that point. So with that, Madam Chairman, I think Mr. Wentland and Director Nesvik worked very closely over a number of months to get the bill into place, and I think it's probably more appropriate to let Mr. Wentland explain how they come to craft the language that is contained currently in the bill. So with your permission, and I'm happy to answer any question at this point, but with your permission, I would have Kit do that.
Any questions before we turn the time over to Mr. Wetland? Okay, go ahead. Thank you, Mr. Larson, Representative. Go ahead.
Good morning, Madam Chairwoman. My name is Kit Wentland, Special Counsel and Tribal Policy Advisor for Governor Gordon. If you would mind, do you mind if I ask Director Nesvik to come up as well?
That'd be just great.
He's been in the thick
The more
of
the
this.
merry up here.
Thank you. He's been in the thick of this just as much as I have.
Sure. Welcome, Director.
Good morning, Madam Chair.
So, Madam Chairwoman, just to sort of recap, this really has emerged from the 2019 Herrera decision, which was a sea change in how the U.S. Supreme Court approaches off-reservation treaty hunting rights. That Ward v. Racehorse case, as Representative Larson mentioned, it had held for close to 100 years or more that off-reservation treaty hunting rights in Wyoming were abrogated and extinguished at Wyoming statehood. That, of course, changed in Herrera. And in the Herrera opinion, it said that that had not happened, and in fact, that right survived for the Crow Tribes Treaty. And then moving forward, there are a couple grounds that the state may have, there are a couple grounds that may justify regulation of that off-reservation right. And those include whether the land is unoccupied, which comes from the treaty hunting clause in the Crows Treaty, that they shall have the right to hunt on the unoccupied lands of the United States. and whether regulation of a hunting right by a state is necessary for conservation. It's important to note those two terms are not solidly defined at this time by binding Wyoming case law. There's case law over the nation, and both issues probably require a case-by-case definition, going through records. It is a significant burden for the state to prove at this point. And that's where we're at. Where the case currently sits is, since it was remanded back from the Supreme Court, it was remanded for decision on two issues: the unoccupied piece, and then whether state regulation is necessary for conservation. It sits in Sheridan County Circuit Court now for decision on just the conservation necessity piece. And right now, that hearing is pending. I believe there's a hearing in March, evidentiary hearing. But I wanted to note one other piece on that case as it's ongoing. I think it's a part of these discussions as well. Recently, I don't remember if it was late December or early January, Mr. Herrera, in a separate criminal case in Montana, was charged by a Montana district attorney with several felonies, and he pled guilty to 3 felonies related to sexual abuse of a minor. That was related to charges of possession of child pornography and methamphetamines. I say that to say that charging decision and then the sentence, that plea agreement that he made, and then the sentencing hearing this Friday on the 17th could affect how the state moves forward with its case. That's still the subject of internal deliberations right now, but just for the committee's information. So where that leaves us then is, that brings us to the present day. As Representative Larson had noted, the Eastern Shoshone came and asked to speak with us in spring about off-reservation treaty hunting in light of the Herrera decision. Because under their 1868 Fort Bridger Treaty, they do have the same hunting clause language as the Crow. That 1868 Fort Bridger Treaty also includes the Shoshone-Bannock as well. They're the 2 signatory tribes. So conversations as they started centered on several shared values: conservation of wildlife, mutual respect for tribal sovereignty, just a simple desire to preserve the ability to responsibly hunt for current and future generations, and then as well as the goal of managing or helping habitat and wildlife thrive through scientifically based management. The Wind River Reservation has a Wind River Tribal Game Code. There are some similarities with the Wyoming Code, and focusing on those shared values seemed like a good place to start. Through those discussions, the governor's office, legislators, and the tribe did come to agreement on bill language, an initial agreement. As was noted, unfortunately, we recently learned that that agreement, that support of the bill was rescinded recently, and that the Eastern Shoshone tribe now instead opposes the passage of the bill. While the governor is sincerely disappointed to hear of that development, he still respects the tribe's sovereignty and authority to make decisions on matters important to tribal members, of which off-reservation hunting is undoubtedly one of those. Despite this change, the governor still believes that the bill is worth supporting through the legislative process. And this is a point I really want to emphasize this morning. The reason for that is because this bill does not by itself unilaterally regulate on or off-reservation tribal hunting. It does not do that. All it does is give the governor the authority to negotiate off-reservation tribal hunting agreements should a tribe choose to engage. It does cabin his authority and the bounds within which he can negotiate. That is true. But a tribe is not bound by anything in this bill unless agreed to through open negotiation through the appropriate authorization process in the tribe and the governor's office. So despite the Eastern Shoshone's change of position, which we respect, we still believe it's a valuable tool to add to the state's bag for this. It allows the state to be proactive should a tribe change their mind and want to work with the state in the future. Should the Eastern Shoshone change their mind, should another tribe approach us with rights and want to speak. And it keeps us from being in a position where we have to be purely reactive to court positions and provide some guidelines for the governor to know what kind of an agreement is the legislature comfortable with. So with that, if you don't mind, Madam Chairman, I'd like to jump into the bill. I'd of course stop for any questions if there are any from the committee.
Any questions, committee? Well, Senator Ellis?
Thank you, Madam Chair. I don't want to overcomplicate this, but I want to emphasize that after the Supreme Court came back to Wyoming with a directions on to remand, the state didn't jump to this conclusion that, it would start negotiating or that was the best path forward. In fact, refresh my memory on how this worked. There were more arguments raised regarding issue preclusion. And so this lingered on in the lower courts. Can you just give us or provide a summary of how that worked?
Yes.
Mr. Wetland?
Madam Chairman, Senator Ellis, of course. So during as part of the Herrera opinion, in one of the footnotes, it was raised that the issue, let me step back. As part of the history of off-reservation treaty hunting rights in Wyoming, there's really two main cases. There's the Ward v. Racehorse case from the 1890s, and then there's Crow Tribe v. Repsis, which is another case from the 1900s, which dealt with, again, I believe it was a Crow tribal member who, I don't remember if it was deer or elk, but a similar scenario, hunted an animal outside of the state's regulation system. And then the Crow tribe sued the Wyoming game warden, Chuck Repsis, over that. That case, relying on Repsis, held that the Crow tribe's treaty right, because of the Ward v. Racehorse case, to off-reservation hunting was extinguished. So that existed in the federal realm, in a federal district court case. What happened then at the Supreme Court in Herrera is in one of the footnotes, because Mr. Herrera is a tribal member subject to that prior judgment, under Repsis at least, the Supreme Court stated that it was possible his ability to assert that same claim under issue preclusion was barred, because that claim had already been asserted and adjudged against the tribe as a whole. So that footnote kind of opened up the possibility that still existed. The state did pursue that argument in circuit court. I believe that it was granted in circuit court, the argument, and then it was denied on appeal at Sheridan District Court, which leaves us now at the end with just the conservation necessity argument. The Repsis case itself is still, there's a motion for relief from prior judgment filed by the Crow tribe in the 10th Circuit Court of Appeals, and it's still under decision now. We don't have a decision yet as to whether that case will be overturned or not.
Follow up.
Follow
Go
up.
ahead, Senator Ellis.
And thank you, Madam Chair. And I was rereading all of this last night. The reason that Wyoming can still litigate on the issue preclusion is because Herrera didn't explicitly overturn Racehorse. Is that part of the rationale and why there's some confusion here? That Herrera left that question open, it didn't address Racehorse.
Go ahead, Mr. Wetland.
Madam Chair, Senator Ellis, the Racehorse case as a whole is not expressly overturned yet. The Herrera decision, the Racehorse case and how the Supreme Court has dealt with its validity is rather complex, to be honest. To the extent that Racehorse held the treaty right was extinguished off reservation, I think the Supreme Court in Herrera spoke to that. The Supreme Court did not overturn, as you're correct, Senator Ellis, the case as a whole. And that case does still exist and is still a valid case.
Other questions? Okay, thank you, Mr. Wetland. Director, would you like to jump in?
Yeah, Madam Chair, members of the committee, Brian Nesvik, Director of Game and Fish. So I think Mr. Wetland did a great job of going through the history, as well as Representative Larson. I think that the bottom line is that because when the Supreme Court made this most recent decision and remanded it back to Wyoming courts, they specifically called out conservation necessity. That's a Supreme Court, that's their own exception that they created, I don't know how many decades ago, dealing with other treaty rights in other states. And that's why we're here today is there's not an explicit specific treaty right without that exception. They've created that exception and said that it applies here, that it can be litigated here is actually what it said. It didn't exclusively say that conservation necessity applied. It said it could be relitigated. So the other thing I think it's important is that these types of agreements do occur in other states. We're not certainly the only state with off-reservation treaty hunting rights. Lots of other states deal with this now, and they deal with the finding common values between two sovereigns through agreements, like is contemplated here in this bill. They vary widely, the contents of those agreements. I would say that I don't know that any of them mirror this bill exactly, but there certainly are, there's a wide range of how these have been negotiated in other places. And with that, Madam Chair, I would stand for any questions.
Questions for the director? Senator Ellis?
Thank you, Madam Chair. And maybe this is a question for Representative Larson. Was it last year or the year before that we appropriated additional funds to defend specifically the Herrera case? Do you remember the details of how much we spent, what year that was, and just that appropriation? I think it was last year's budget
I think it was the year before
or the year
supplemental
before.
budget.
Do you remember the amount that we appropriated?
Any other questions? Mr. Whitlam, did you want to go ahead and go through the bill? Just give us the highlights of what you'd
Madam
like to-
Chair, of course. I'll just go page by page. It's admittedly a simple yet complex bill. Like so many bills. So just starting on the first page. Article 11, agreements with tribes. And I think, again, this is the important piece to underline. There is no agreement on off-reservation hunting between the state and the Eastern Shoshone right now. We have not negotiated that. That has not happened. And this bill does not regulate their rights unilaterally. It provides the sideboards within which the governor can negotiate, so he knows what the legislature may accept, and then provides him the authority to go and enter that agreement without the need for legislative ratification. Moving on to page 2, we start getting into the beginning of the bill. Authorization to negotiate and enter into agreements with tribes concerning hunting, fishing, trapping, and gathering. The reason this says hunting, fishing, trapping, and gathering is many times those can be included in what is termed hunting under a treaty. Not in every treaty, not for every tribe, but the ability to at least have that tool if we're in the range of negotiating. It just helps be able to negotiate pieces that may be important to a tribe. So on the beginning, the governor on behalf of the state is authorized to negotiate and enter into an agreement between the state and a tribe concerning a hunting, fishing, trapping, or gathering rights claim based on a treaty or other recognized federal right on lands located within the state. So importantly, this is cabined within the state of Wyoming. And if a tribe has a valid off-reservation treaty hunting claim, it allows then them to approach the governor and say, we'd like to talk. And the governor can say, I have the authority to reciprocate. Section B, any agreement executed under this section will be in writing, signed by the governor and the governing body of the tribe. In the event there is an agreement, of course, each tribe, they have their own specific process for whether a general council or a business council or a subcommittee or whatever it might be has that authority. That, of course, would have to be respected to each tribe as it comes up. And we would have to learn about that through talks with each tribe. Under Section C, this provides those sideboards for the governor. Because, of course, the legislature would be saying, we're comfortable with you doing an agreement, but these sideboards help the legislature know that a good agreement that protects the state's interest in hunting and its conservation system, they have an idea that those pieces are being protected as well. Under Romanet 1, provides the governor shall renegotiate the agreement if it is or becomes inconsistent with any state statutes. I mean, just at a basic level, of course, at a regulatory level, there's going to need to be harmonization no matter what. But at just a fundamental statutory level, that provides the avenue for a release valve, a way to come back if we need to fix something. Romanet 2, the tribe has adopted a game code or other similar enforceable regulatory mechanism that provides for the issuance of tribal hunting, fishing, trapping licenses, and adopts or incorporates the substantive requirements of 23.3.101 through 23.3.407. I want to stop and focus on this point quickly. So at the beginning, this is just a requirement that a tribe, if there's an agreement, again, the state cannot force a tribe to do this with or without an agreement, that there's a licensing system, a tribal licensing system. And this would be a tribal off-reservation hunting code licensing system, most likely, though specifics around that always are going to have to be negotiated. These provisions are not the full game and fish code. I would also defer to the director for any specifics on this, but these are just foundational hunting and conservation principles that are likely found and mirrored already in several tribes, many of them at least, in several tribes' hunting codes. Licenses, bagging limits, hunter's orange, things like that. Many of those principles at a foundational level are found in other tribes' codes. They're not the same. I don't want to oversell that. But that's where that shared value of conservation and wildlife management, we believe, exists. Moving on to Romanet 3. The governor finds that a tribe would have the ability to effectively enforce its code. That's just, there's an off-reservation code. There's ability to negotiate that the tribe itself is enforcing it on its own members, just that they have the ability to do that. Romanet 4, tribal members who do not possess a valid license. Romanet 4 and 5 are simple and complicated. I think I just want to focus on two main points. Romanet 4 says if there's no license, no state license, no tribal license, nothing, then a state game warden could cite. However, if there's a tribal license, in Romanet 5, the state and the tribe would end up negotiating a system where either a tribe or the state would enforce hunting, off-reservation hunting. The way that works then is just the license tells you which system you're under. And it very well could be that you end up negotiating that the tribe is the only one who can enforce a tribal off-reservation code against tribal members in tribal court. There's also the flexibility to negotiate state input if a tribe were to be open to that. But this provision does not say that the state will cite tribal members under their tribal code. Moving to subsection A on the next page, really subsections A through D, these are just the basis of trying to create harmony between the state and the tribe system. It would benefit both the state and a tribe if there's some harmony in seasons, in area closures and bag limits, in collecting and sharing harvest data, just to ensure that the people that are out there hunting can keep having that ability to hunt in good areas where they live. And in subsection A, it does provide for the flexibility to negotiate exceptions. Different tribes may have different religious ceremonial uses they want, or seasons they need for hunts, whether that be in spring or in summer. The ability to just negotiate those and say, okay, that's what that is. We understand, we can figure that out. That provides the release valve to be able to talk about that. And then in section D, quotas, daily limits, possession limits. Again, these don't mandate that they follow the exact same limits as the Game and Fish Commission, just that they harmonize and they further an interest in conservation. Moving to Romanet 7, this sentence where it says tribal hunting, fishing, those rights will be subject to the state's right to regulate when necessary for conservation. What that means is this agreement stands in place of a court argument over conservation necessity. The tribe and the state are agreeing on what conservation necessity means through an agreement, not taking it to court. Section D just protects private property rights. Pretty straightforward. We don't believe that an off-reservation treaty hunting right extends to people's private property rights, regardless, but wanted to make sure this was in this bill. A definition of gathering. Gathering, we've learned, is important to several tribes. This definition just tries to point out that this is like going out and picking choke cherries or buffalo berries. If you're making jelly every year, this isn't a commercial operation. This isn't a mining operation for minerals. This is going out with your family, whatever the foraging or gathering activity might be on lands.
Madam Chair.
Senator Ellis?
Thank you, Madam Chair. Is gathering used in the treaty language? My understanding is that the Treaty of Fort Laramie is limited to hunting only. So this bill was, I'm guessing, an attempt to be more cooperative with our tribal partners to include fishing, trapping, and gathering. But those terms aren't used in the treaty. Is that correct, Mr. Wetland?
Mr. Whitlam?
Madam Chair, Senator Ellis, in the 1868 Fort Bridger Treaty, that term is not in that treaty. Gathering is not. I don't believe gathering is in the Fort Laramie Treaty either, but there are tribes with treaties that do talk about gathering. That does exist out there. I think you're correct. We learned this was something that was important, which is why we tried to be cooperative and talk about it. Truth be told, I think tribal members are also, Wyoming tribal members are also Wyoming citizens, and they would likely have the same right to gather those materials on state lands or federal lands as another Wyoming citizen would.
Yeah, follow up, go ahead.
Follow up, but without this agreement, then they'd be just subject to state regulation, period. If they're doing off-reservation gathering.
Madam Chair, Senator Ellis, since gathering is not necessarily included in the off-reservation hunting right, I think regardless of an agreement under gathering, they would be. However, there's really not a lot of restrictions on gathering. It's something that's pretty open right now, especially on state lands. I can't speak fully on federal lands. Of course, defer to the director for any specifics.
Yeah, Madam Chair, Senator Ellis, certainly the state of Wyoming doesn't have the authority to regulate, let's say, gathering TP poles, live trees on forest lands. However, what we did is we discussed this with the tribes. Again, they indicated that this was very important to them, that we said we would put this in the bill so that the governor had that ability to either help that along or negotiate for lands where the governor does have authority, or at least a state entity like the State Land Investment Board has authority to regulate gathering. But you're exactly right, that fishing or gathering is not contemplated in any of the treaty language, or trapping, yeah.
Madam Chair.
Yeah, follow up,
Madam
Senator
Chair,
Ellis.
thanks. My recollection on gathering is this is more of an issue when it comes to national parks, where there are prohibitions on that kind of activity. Is that fair?
Director?
Yeah, Madam Chair, Senator Ellis, and I actually think too on national forest lands, because there are prohibitions against taking live trees, and sometimes tribal members want to take live trees for TP poles and other things like that. And so there probably is some regulation, not only in the parks relative to trees.
Thank you. Go ahead, Mr. Whitman.
Thank you, Madam Chair. So Romanet 2, this defines tribe. It just defines the word tribe as a federally recognized tribe. Ironically, we only had one statute in the Wyoming statutes defining that, so we used that one. Section 2, this says that the governor's office would submit a report to the joint TRW interim committee within 10 days of completion of an agreement. Section 3, to the greatest extent authorized under state and federal law. This just gives the Game and Fish Commission and SLIB the ability to implement regulations they may need to do to implement an agreement, which falls in line with the broad regulatory power both have for SLIB has, or sorry, not SLIB, State Board of Land Commissioners. State Board of Land Commissioners has this authority to regulate state lands. And in case, while we do not believe unoccupied lands include state lands, if there were to be negotiations and an agreement, that's something the state and a tribe could talk about. And were that to ever come into an agreement, State Board of Land Commissioners would have the regulatory authority to do rules needed to implement that agreement. Game and Fish would then have the regulatory authority needed to implement an agreement. And then Section 4 makes the act effective immediately upon passing through all the requisite legislative steps. I know that's a lot, and I've talked a lot, so I'm happy to sit for any and all questions the committee may have.
Questions for Mr. Wetland, committee? Thank you for the overview. Appreciate that.
Thank you.
How about for Representative Larson or the director? Anything else you'd like to add to the bill, either one of you?
No, thank you, Madam Chairman.
Thank you for the history and the background. I appreciate that. So, well, with that, then we'll go ahead and open it up for public testimony on this bill. So anyone in the room that would like to testify, I know we have a few people online, but we'll go ahead and take the folks in the room first. So anyone in the room that would like to come up and testify on this bill, please come up. No takers? Okay, well, in that case, I guess we'll go to our online testimony.
Madam Chair, there is no one with their hand raised right now. I would just ask if anyone would like to. Oh, we've got a few people raising their hands now.
Okay, great.
Madam Chair, we have Jason Valdez, Jody McAdams, Nathan Small with their hand.
Let's take Jason Valdez first.
Good morning.
Welcome.
Thank you. Thank you for the opportunity. It's good to see you all this morning. It's and the importance of this bill. It's good to see that there's an effort for a government-to-government relationship by authorizing the governor to negotiate with the tribes However, I think that there are constraints placed on these negotiations in the proposed section 23(1-1101) C 1 through 7. And this section actually makes the ability to negotiate and the likelihood of reaching an agreement near impossible, mainly because we should be reminded that the treaty supersedes statehood. And the sections of Section C really shred tribal sovereignty by essentially placing the entire tribal fishing game code under the direction of the state in the following ways. Section 1 voids the agreement if it becomes inconsistent with any state statute. Section 2 requires the tribes to adopt a game code that mirrors a state code. Section 4 appears to reverse the Supreme Court decision in Herrera versus Wyoming. Section 5 places tribal members who violate the tribal game code under enforcement or authority of the state. Section 6 essentially puts the entire game and fish seasons and quotas under the direction of the Game and Fish Commission. And Section 7 states that all tribal hunting, fishing, trapping, and gathering should be subject to state regulation whenever the states deem it necessary. All of these effectively eliminate tribal sovereignty, leave the governor very little, if any, room to actually negotiate. These violate our established treaty rights for the Shoshone tribe. And so it's inconceivable, really, that any tribe would agree to these, even if the bill were to pass. And it's a little bit striking that so many members of the legislature support this because of the fact that it does undermine the Shoshone tribe's sovereignty. Not too many years ago, we passed the Wyoming Indian Education for All bill, very important in educating our young people across the state. I think we could implement some of that curriculum there at the state level to inform more of our legislators about our history. There's Secretarial Order 3403 at the federal level that talks about co-management and cooperative agreements. And much of this language, I think, would be beneficial for the state to look into so that we can think more effectively about how we better manage our resources. I would suggest also looking to the tribes and in our efforts for wildlife conservation and protection as an example of what the state could also implement on off-reservation lands. For instance, the protection of wolves and bears, the reestablishment of these migration corridors, the importance of the Greater Yellowstone ecosystem and its integrated parts. The tribes are very important in that and have a history of conservation that we could learn from at the state level. So I really appreciate this conversation today, and thank you for the time, Chairwoman and committee.
Questions for Mr. Valdez?
Thank you.
Yeah, Senator Ellis.
Thank you, Madam Chair. With your indulgence, I just want to explain a little bit about why my name's on the bill and why I think it received so much support and why it was unamended in the House, just to backtrack on some of that. When the Herrera decision came out, we actually had a Tribal Relations Committee meeting, and there were members of the Shoshone-Bannock who came to listen to our hearing, get up to speed with what was being discussed, and in some sidebar conversations, one of the discussions that we had was why wouldn't we just negotiate and figure this out, and rather than leaving it to the courts? And at the time, as you heard from Mr. Wentland, we went on a different path. We wanted to discuss the issue preclusion on the remand, and the litigation continued and has been continuing. So I was delighted when I heard that the governor's office was interested in having conversations with the Eastern Shoshone tribe about negotiating, letting the states and the tribes define its own path rather than relying on the courts. And to me, the paramount importance of having that in place was that rather than relying on individuals to have to break the law, maybe be subject to poaching charges, have criminal charges brought against them, that would be the only way we'd test the further bounds of what are unoccupied lands and trying to sort through some of those things. So to me, negotiating seemed like the more responsible path. We have a letter that was initially signed by the Eastern Shoshone, and my discussions and conversation with the governor's office was, this was the language they liked. Please don't amend it. That'll change their level of support. So I just want to offer that was the reason that I put my name on it and the reason I supported the bill. I continue to support the concept of the bill for all the reasons I mentioned, and unfortunately, the position has been to kill the bill rather than to amend it. So looking at the bill, you mentioned that beginning on page 2, paragraph C, and all the following Romanettes that go on to page 5 are there's the offending language. And so my question to you, Jason, is if we were to remove some of that language, keep this a simpler bill that simply says the governor shall negotiate with tribes. But I think as a legislature, we want to make sure that, just have our blessing on it, maybe ratifying that agreement. If we were to simplify the bill in that way, does it get you closer to feeling more comfortable with the bill?
Aldous?
Thanks, Senator Ellis. I would suggest removing all of section C, 1 through 7. Those sections are really the most of interest, but I think that the governor, essentially, as the governor, has the authority already to negotiate with the tribe, and has done so in previous instances, like the casino. So I don't think codifying or putting restrictions on the tribe's authority that already exists in the game code, that the tribe would want to ever seek to undermine that. We have to remember that the reason why the tribes implemented a game code in the 80s was because the state was going to assume jurisdiction on the reservation. And so the tribes are always apprehensive about the state coming in and assuming jurisdiction or undermining sovereignty and self-determination. So I think that any agreement that is made, and I can see that this is being worked through, but there's some real concerns still about the undermining of our existing authority.
Follow-up, Mr. Chair?
Yes, go ahead.
Follow-up, Madam Chair. I think that the reason that you see legislation is also a show of faith that the legislature stands behind the governor. And it's not difficult to imagine a scenario where if the governor were to negotiate an agreement and it contained provisions that maybe some state legislators didn't like, and then the state legislature might pass laws that conflict with the agreement. I think that's the situation we're trying to avoid by having some kind of legislation in place. Do you have a response to that?
I think that this bill happened very quickly and it moved, fast. And I don't think that there's been adequate time to visit with our other neighbors. I'm meeting with the Shoshone Business Council later today. I met with them last week about this bill and other issues. And from our sister tribe, our relatives over the mountain in Choban, there has been some issues. Most tribes are not negotiating with the states because it undermines their sovereignty. And so this is taking a step a little bit further than what we're adequately prepared for. I'm in a different position. I'm not an elected official for the Shoshone tribe, but I am involved with some issues about conservation and so from what I've understood is that we want to take a little closer look at this to ensure that if the decisions are being made, that it doesn't, in fact, undermine the ability of the tribes to exercise our sovereign right to hunt, fish, and gather on our traditional territory established by treaty. And so I think we just have to make sure that is being adhered to.
Yes, go ahead, follow up. Senator Ellis.
Thank you, Madam Chair. Just one last follow-up question. So there's nothing in this legislation that binds the tribe to show up. The governor can ask for a meeting and say, we'd like to start negotiating and working through some of these issues. And if Eastern Shoshone doesn't want to show up, they don't have to. So, if we were to maybe amend some of this language, at least have it in place as a workaround, and then revisit it as a sign of good faith. I'm just trying to get us there. And the reason that I feel like this is important is the governor has been, I think, really working very diligently to build relationships with both of our tribes, is trying to find the resolution. I don't know that Wyoming will always have a governor who's that committed. I look at the work that we do in our Select Tribal Relations Committee with my co-chair and I don't know that you'll always have legislators who believe in sovereignty as much as we do and want to support our tribes. So I think there is a little bit of an urgency here to try and see if we can come up with a solution when you have, from the state perspective, individuals who are really trying to work with our tribes rather than have an antagonistic relationship. So, if we were to pass something, maybe make some amendments to the bill, there's still time for us to amend it in a future legislature, or if the Eastern Shoshone decides it does want to come to the table, then at least that mechanism's in place so we don't lose a year. So I'm curious to know your thoughts on, now that you kind of understand where I'm coming from on some of that, if that might change your perspective at all.
Well, I think it's important that we continue to have conversations and work through some of those details. And so, my recommendation, based on some conversations I've had, is that there's problems with that section C 1 through 7. If we were to take that out, that there is, that moves us a little bit further along to having some support. But again, as not a representative for the Shoshone tribe, but I visit with the leadership fairly regularly, and we'll be meeting with them later today. I think that they would be glad to know that if we were able to remove that language, that gets us a step closer to some sort of an understanding. But again, I can't speak on behalf of leadership. I'm a Shoshone tribal member involved in conservation, primarily around bison, but also water and land and conservation of many of our species overall. So hunting and fishing and gathering is a treaty right. And we have that on our own homeland, and we should have that in our traditional territories. How that happens and the negotiations that need to take place, I may not be privy to that. That'll come from our leadership. But just being able to express myself as a Shoshone tribal member and upholding our treaty and our treaty rights is very important for myself and our community. And so I just wanted to thank the committee for taking this step and working to support the sovereignty and self-determination of the tribes. That's a shift. We don't always often see that. And I was very supportive of seeing that Wyoming Indian Education for All bill happen several years ago. The state is working more diligently to include the tribes, and supporting sovereignty and self-determination needs to be well understood by our legislators. So I thank you for your time and for your questions, Senator Ellis. Appreciate the committee and look forward to working with several members in the room there on additional items in the future. So thank you.
Thank you so much, Mr. Valdez. We appreciate your testimony.
Thank you.
Who do you want to let in next?
Madam Chair, we have Jody McAdams.
Okay, go ahead and let her in, or him. Not sure if it's a he or a she. It's a she? Okay. Welcome, Ms. McAdams. We'd love to hear from you. Oh, you're muted. Can you unmute yourself?
Sorry about that.
Oh, it's all right. We can hear you now.
Thank you. I'm an enrolled member of the Eastern Shoshone Tribe, and I'm also a former member of the Shoshone Business Council. And thank you for allowing me to speak today. So I think we need to get back to the very basics. The Eastern Shoshone Tribe is governed by our Shoshone General Council, which is our tribal membership. The Shoshone Business Council receives their direction from the Shoshone General Council. This bill was never brought before our discussions, or anything was ever brought before our people. The Shoshone Business Council took it upon themselves to enter into negotiations to speak about this bill, but they forgot a very important first step, which was to see if this is what our people wanted. We found out that the Shoshone Business Council has been negotiating with the state since May of last year, and yet nothing was given out. No information about this was given to our people. So, to be fair, our people need to approve this first before the Business Council can enter into any agreement with the state. And a lot of discussion has gone on in the community, and that was why and with other tribes, this bill could affect a lot of other tribal, other tribes that have treaties. And so it's very important that we look at this and the ramifications of entering into an agreement. But right now, it just seems to be so backward to me. The Shoshone Business Council has withdrawn their support for this bill, and the Shoshone tribe, the membership, like I said, has not known about this bill until just recently. And most of us learned about it through the social media or the media. So why is this bill continuing without support or consent of the Shoshone tribe? I guess that's my question to all of you. Why is it continuing to move through the process when it does not have the support of the Shoshone, Eastern Shoshone tribe?
Questions or comments for Ms. McAdams?
Madam Chair.
Go ahead, Senator Ellis.
Thank you, Madam Chair. Thank you for being with us to testify today. You know, the feedback I've received over email is really the section C and all of those provisions. And I would agree with you that it already predetermines how the negotiations should go. So if we were to trim this back, simply say that we want the governor to negotiate or have the authority to negotiate with tribes. And then again, if the Shoshone General Council deliberates and determines that it doesn't want to negotiate, then it doesn't have to. And if that there's nothing in just removing some of that language, but then you would have time to allow for those internal conversations to happen. If the council determines that it wants to go down that path, it can, but if it doesn't have to. And so what I think we're trying to do is just support our governor as a legislature in giving him this kind of authorization and support. So I think that's at least my intent, at least, and happy to, look at removing all of that paragraph C and some other additional language. Would that help with some of your concerns?
No, not at all. It needs to go back to the Shoshone General Council, to our membership. It needs to be the people, the whole tribe as a whole. It's our decision as tribal members if we want to enter into an agreement or not. This is the hunting is a treaty right. It's very, very basic. It's a basic treaty right. And like I said, why is this bill continuing when it doesn't have the support of the Shoshone tribe?
Go ahead, Senator
It's
Ellis.
like why would the state take it upon themselves now to try to govern us? We're a sovereign nation, and it's up to us as a sovereignty to create our own laws. And at that point, having said that, at that point, then it would be up to us if we want to enter into an agreement.
Madam Chair?
That's the bottom line.
Go ahead, Senator Ellis.
Thank you, Madam Chair. I think the intent, and certainly mine, is if you have a Eastern Shoshone tribal member who hunts off reservation and the Game and Fish says, you're violating state law, we're going to arrest you. And now you've got court proceedings, criminal proceedings, and significant fines. And that Eastern Shoshone member might say, no, I have an off-reservation hunting right. In the moment that offense occurs, the Game and Fish warden's going to say, whoa, that's way outside my realm of determining whether or not this is unoccupied land according to the Herrera decision. And so I'm going to guess they make that arrest, and then you have individuals who are subject to criminal proceedings. So that's the scenario I'm concerned about preventing, and want the state to work with our tribes proactively so that we can come up with agreements so that tribal members don't have to be put in that awful position to exercise their hunting rights. Any thoughts?
I can understand that, Senator Ellis, but it does not have the support. The basic bottom line is this bill does not have the support of the Eastern Shoshone tribe. You've kind of, I think, misstepped. It's like, why did you not come to the membership and get approval before proceeding with this? It just baffles me. How could you make a law or try to govern without consent, without the tribe's consent? And to continue this bill, I'm sorry, and to continue it. It just makes no sense to me. I think my suggestion would be to wait until our tribe meets on this. Before this bill goes any further, it just makes no sense without our consent.
Well, thank you so much for your testimony, Ms. McAdams. We appreciate it. And we'll see where this goes. Thank you. Appreciate it. I think we have someone else online.
Madam Chair, we have Nathan Small online.
Okay. Would you bring him in, please?
Yeah, good morning. I'm Nathan Small. I'm the chairman of the Fort Hall Business Council for the Shoshone-Bannock Tribes here in southeastern Idaho. I'm testifying before this committee to oppose the proposed legislation that would create a line of authority for the governor of Wyoming to enter into agreements with tribes. The stated goals of these potential agreements would be to define treaty reserve hunting, fishing, and gathering rights for the tribes exercising hunting rights in Wyoming. We believe these arguments are unnecessary. We believe these agreements are unnecessary. The Shoshone-Bannock tribes were present and signatories to the Fort Bridges Treaty of July 3, 1868. However, we formed a distinct political subdivision here in Fort Hall, so our statements reflect our views on the legislation and do not represent any other tribe. From the time we signed the treaty, our rights to hunt off reservation has been under attack. Along with our sovereign authority to self-regulate, our members are issuing permits, establishing our own subsistence bag limits, and ensuring the burden of conservation does not fall squarely on us. A critical component of federal law is that treaties are not a grant of rights to a tribe, rather they are a reservation of a right by the tribe. A recognition that the inherent powers of tribes include all aspects of internal governance for their members. Plainly stated, the tribes specifically reserve the sovereign authority to regulate all aspects of reserved hunting, fishing, and gathering treaty rights internally for their membership by passing tribal laws, regulations, and harvest guidelines for each activity free of interference from state regulation. The critical context for this point is that tribes are not required to externally collaborate with any agency prior to implementing an activity protected by the reserved treaty right. Quite literally, the treaty signed by the United States and the tribes is the agreement. Because the Shoshone-Bannock tribes have always been a steward of our homeland, we consistently engage in co-management for natural resources within our federal, tribal, and state partners, particularly for those species listed under the Endangered Species Act. The intent of our collaboration with external entities like states is to ensure that our natural resources are sustainable and our members are treated equitably when assessing those treaty areas. Our tribal government demonstrates our commitment to our homelands by implementing millions of dollars worth of fish and wildlife projects every year. Stewardship requires evaluating the effects of harvest on different species, evaluating population dynamics for the species sought, and recognizing long-term trends in population. In every sense of the word, the tribes do not have an adversarial relationship with the states. We are a partner in virtually every aspect of management with our respective co-managers. A necessary component of our effective management includes the need to enforce tribal regulations when needed and to clearly communicate those regulations to our partners ahead of each season. White House Bill 83 includes a reference to those conditions and places additional barriers on self-governance that would increase the likelihood of multi-jurisdictional conflicts arising from a single incident. The Shoshone-Bannock tribe has always promoted a cooperative relationship among our federal, state, and tribal partners, but specifically retain the right to regulate the conduct of our membership under the treaty. The proposed legislation also appears to set a context that would limit tribe sovereignty over the management of reserved right to hunt in Wyoming outside of the external boundaries of the reservation. Rather than acknowledging the tribe's inherent sovereignty to manage treaty hunting and to propose legislation to place a sideboard on reserved rights that are not necessarily consistent with current management of off-reservation hunting for some tribes with ties to Wyoming. The Shoshone-Bannock tribes have never entered into any agreements that would constrain or otherwise impede our management authority under the treaty, and we will not engage in a negotiated agreement as laid out in the proposed legislation. The Shoshone-Bannock tribe see the potential to be an active partner, a co-manager in natural resources, management across our homelands in Wyoming, ensuring that our resources are available for future generations. Our reserve treaty rights will not deplete the resources we are discussing today. The purpose is to rely on our perspective on this legislation is to ensure that our cultural subsistence and traditional practices are clearly communicated in this committee. Tribes have an inherent right to engage in self-governance over treaty hunting, and we would further recommend additional fact-finding on this issue. The Shoshone-Bannock tribes remain open to questions and discussions with Wyoming legislatures to better understand federal treaty rights within the state of Wyoming. In summary, Chairman of the Travel, Recreation, Wildlife, and Cultural Resources Committee, the Shoshone-Bannock tribes remain convinced that the proposed legislation is unnecessary and we remain opposed to House Bill 83. Thank you, and if you have any questions, I'll stand here to answer them.
Thank you, Mr. Small. Are there any questions for Mr. Small from the committee?
Madam
Senator Ellis.
Madam Chair, thank you so much, Mr. Small, for being with us today. I want to put a finer point on it. If we were to remove some of the provisions in paragraph C that contain all that additional language, I think the reason this bill is important is it signals a shift of the state of Wyoming's position. Prior, when Herrera was first issued, the state's position was to continue to litigate. The issue preclusion issue was something that was ongoing, and rather than engaging in conversations with tribes, it was continue to rely on litigation and fight these rights. This bill is really encouraging to me in the sense that at least it marks a shift of working with tribes to find common ground. So that's my question, and that's the reason why it's not so easy for me to let this go, because I do think it's important for that reason. If we were to remove that language found in paragraph C, starting on the bottom of page 2, going all the way through 3, 4, and 5, does the bill start looking a little bit better in your eyes if we get rid of some of those language that would encourage our governor to work with your tribe, have those conversations, meet, discuss things like co-management? That's the position I think Wyoming should be going in, rather than relying on, litigating and fighting the off-reservation, the acknowledgement of off-reservation hunting rights. Your thoughts?
Mr. Small, go ahead.
If the state of Wyoming would acknowledge the treaty and then acknowledge the rights contained in that treaty, then we can sit down and then let's talk about what's going on in the state of Wyoming. You talked about conservation. We are also conservationists. We're not out there to kill or to reduce any of the wildlife out there to the point of where it may become extinct. That is the last thing that we would consider doing. All right, our treaty is with the United States, not the state of Wyoming. We do not hunt on state land. We do not hunt on individual private lands. We only hunt on unoccupied lands of the United States, and that is all Forest Service, Bureau of Land Management, any land that is controlled by the federal government. That is where we are at. And that is how we are able to continue to do what we do here in Idaho and even in Montana, where it's been recognized, that we do everything that we can to ensure that we are not the ones that are causing a conservation problem. We've always been that way. Our regulations state that you only take what you need, not what you want. So it's not like the idea that we're going to be coming into Wyoming thousands at a time and decimating herds. That's not what we do. That's exactly what we do not do. So to me, when you start trying to put the state of Wyoming in some type of a control of where our treaty rights, we would definitely be opposed to that. All we are saying is that the state of Wyoming should finally recognize the rights under the treaty of Fort Bridger. Now, we've always been told that the treaty is the law of the land. Maybe Wyoming should understand that and respect that and do work with us. And it's only on the federal lands. It's not any place else. So, that's just something that we've been doing a lot.
Okay, thank you so much. Any other questions? Appreciate your testimony today. Thank you for appearing today. Appreciate it.
Thank you.
Anyone else online?
Yes, Madam Chair, we have Mark Harris.
Okay. Welcome, Mr. Harris. Go ahead.
There we go. Trying to unmute. Thank you, Madam Chairwoman. I should clarify from the start. I do not speak for anyone except myself. I've been a resident of the Wind River Reservation for 20 years now. I have worked with both tribes for over 30 years in addressing some of their concerns with legislation. My family, friends, and neighbors are familiar with my history, and sometimes when they have concerns about legislation, they share that with me. Since I've sent you written comments, I won't go over all of those again. I would hope to just kind of share a different perspective. I have not heard any concerns about the fact that the legislature is finally directing the governor to establish a government-to-government relationship with all tribes. Because in section 1, it does say a tribe, not a specific tribe. That I would take to mean that that government-to-government relationship would be recognized with all tribes. And section C, Senator Ellis is spot on. That's where I've heard the most concern. And while I understand Mr. Wentland's comments, sometimes perceptions of the same language are totally different. If I go to subsection 6 on page 3, that whole section, the way the concerns that have expressed to me are the tribe agrees to, and if you read through that entire section, it says the tribe agrees to accept the authority of a commission appointed by the governor. Set appropriate quotas set by the commission in subsection D in Romanet 6. I think that's the concern throughout this section, is that all of the conditions that are being imposed on the tribes are being set primarily by the Game and Fish Commission. The state of Wyoming certainly doesn't have authority over a sovereign nation, and saying that a commission appointed by the governor of the state has the authority now to set seasons, because while it says appropriate, it's probably not going to be appropriate if it doesn't agree with what the commission sets. And that's the concern my neighbors and family have expressed to me, is that whole section says, we will tell you how to run your program. I think everybody that's mentioned the rest of the bill are excited that government-to-government relationship is finally getting some written verification. But allowing the state or any board or commission of the state to determine how all tribal members are governed just isn't acceptable to them. And I'd be happy to answer any questions if I can.
Questions for Mr. Harris? Go ahead, Senator Ellis.
Thank you, Madam Chair. Thank you, Mr. Harris, and former legislator, senator, state senator in Wyoming. We don't forget these things. If we were to remove all of section C and then most of, D, E, and then leaving some of the other remaining items, would that help allay some of your concerns?
Mr. Harris?
It would, Madam Chairwoman, it would certainly allay my concerns. It would address concerns that have been brought to me. Other enrolled tribal members have expressed their concerns, and so I can't speak to that. But the concerns that have been shared to me would certainly be addressed by that action.
Thank you so much for your testimony. We appreciate that.
Thank you, Madam Chairwoman, and it's nice to be back with TRW again.
It's a great committee, so
It is one of the best.
thanks again. Anyone else online? we have one
Madam
more?
Chair, we have a call-in listener who I believe is Diana Mitchell, so I will allow them to talk right now.
Okay.
Ms. Mitchell, if you hear us, please unmute.
Do we want to come back maybe, and if she shows up later, we could maybe, oh, okay, good enough.
Madam Chair?
Yes,
Madam Chair, I know this won't do justice, but I did receive a text from Ms. Mitchell. She, I can't see it with my old lady eyes, but more or less opposition to House Bill 83, I think, covering some of the points that were brought up.
okay.
So I
Good enough.
apologize, Ms. Mitchell. I know I'm not doing your letter justice.
Okay, so don't worry about that then. So, any last words from our representative or Game and Fish or the governor's office? Anything else you'd like to bring it home with?
Madam Chairman and committee, I think the comments are really interesting to me. And I think this bill is in response to some of the same issues we hear from the Shoshone tribe. But I think it's really important to understand as you look at this, as the governor come into this whole conversation, it's how do we lay the groundwork to having some sort of conversation with the tribe. Nowhere in this bill does it specify Eastern Shoshone tribe. It doesn't identify a tribe. If you're wanting, as we, as a sovereign, are trying to figure out what might be an appropriate framework for conversation from other tribes, it seems logical to me that you would engage with the tribe to see what that might be. Hence, that conversation took place from May to October. It wasn't crammed down. It was a long process from May to October where these items are identified to say, if we're granted, if the governor is to have these conversations, what are some of the things we need to talk about? We heard from Mr. Valdez and we heard from Jody, Miss McAdams, that this their concern was that in the governance of the Eastern Shoshone tribe, it's the general council that is the governing body, and we on tribal relations understand that, and the business council kind of is this portion of them that they elect to administer over the affairs, and they express concern that whoa, the business council's getting out there ahead and having these conversations when we didn't approve it. We get that. We get that completely. That's why we have this bill, because we're the same way. We don't like the governor getting out in front of the legislature and just on his own free will going out and saying, this is what we're going to do. We want to give the governor the authority with some guidelines on how to have these conversations with the tribe. So their concerns are valid, but please respect, we have the same concerns. And the governor doesn't just have the right to go out and negotiate these types of things. And they full well understand that. And so as much as there's concern particularly from one of the public comments on why is this bill moving forward, And why doesn't it die? Because this bill isn't specific to one tribe. It's not. It's laying the groundwork of how we have this conversation for all treaty rights, which we're trying to figure out a path forward to negotiate and provide those opportunities. I would just say, one of my heroes is Senator Ellis, and I can't tell you how important her work in the legislature is. And she talks about in here about doing away with Section C. My personal opinion, I don't know that I would do completely away with all of Section C, because as much as they don't want a lot of restrictions, I think that there's some components of Section C that are still important. I think you could get rid of 6, Roman 6. I think you could do it part of 2, but I don't think that it's. I think that we want the governor to find out that the tribe has the ability to enforce the provisions of their game code. I don't think that that's shining any bad light on the tribe, but we have concerns too. And that'll be part of the conversation. So as we try to have some of that framework, I would just ask that you kind of contemplate some of that and say, is policy horrible? Do we not want the governor to renegotiate the agreement if it's in conflict with our state statutes? I would hope we would, but you're the committee, and you get to do that.
Madam Chair.
Senator Ellis, do you have a question?
Thank you, Madam Chair. So I think the question that I've been struggling with is there are all these parameters in here. And I understand the concern some of this finds, the language is a little maybe heavy-handed, condescending. The governor finds that the tribe has the ability to effectively enforce the provisions of its game code. If I were a tribal member, a leader, I'd say, well, thanks a lot. Do we have this kind of language when it comes to the state of Idaho? Do we have to,
Yes.
say, hey, Idaho, we need to find that you have effective enforcement provisions? So aside from that, I think the concern that I'm hearing and wondering is, does it have to be codified in this bill, or are these provisions of the agreement? If we were to remove some of this language, let the tribes in the state, or a tribe, and you're right, this doesn't just apply to Eastern Shoshone, it could apply to the Crow tribe and other signatories to some of these treaties, that these are provisions contained within the agreement themselves, not necessarily, and those are agreed upon on a per tribe basis, versus it being set in stone right here, and this is the starting point for negotiation. So that's my interest in maybe taking out all of C. I don't think all of it's bad necessarily, if we just want to use those kind of terms, good and bad, but maybe we don't want to share some data, or there's an agreement where they don't want to share data about their harvest, in paragraph big C on page 4, lines 11 and 12. So that's where I'm just trying to afford more flexibility. And I think that might help this bill along a little bit. But at the end of the day, I mean, there's not a lot of love for this effort to begin with. So for those of us that we're trying to support our tribes and signed onto this bill, we are in a real pickle. This is not a pleasant thing to be working on.
Go ahead, Representative.
Madam Chairman and Senator Ellis, indeed we do, when we negotiate with other states, say, this is what we expect. And so if we're dealing, I don't think, let's not be offended where no offense is intended, because we're dealing sovereigns to sovereigns. And so if we expect other states to comply, when we have the governor negotiate with with CMS, for example, we have this same language. So this is, to me, this is not condescending at all. It's not intended to be condescending. And so I think we need to be careful not to imply that it is. But I think there's portions of that we can. But on the other portion of that, as the legislature of Wyoming, as we want the governor to go out, is the concern on the House side is we're giving broad authority to the governor. We're giving the governor this authority that he can go out and negotiate, and we're sitting here fidgeting our thumbs because hunting is really important to the citizens of Wyoming, the non-tribal citizens of Wyoming as well. And so how do you accommodate both interests. And they want some sideboards. They want some sideboards for negotiation, and I think the legislature does too. The citizens of the state does as well. And so I think having some of that stuff in C in there, I think you could do away with the last half of C Roman at 2, where it talks about all the game and fish codes. I mean, that goes from the type of gun you can have to the using dogs or whatever. But I think for the citizens of the state to know that whatever tribe we have an agreement with has a game code or similar enforceable mechanism, I don't find that offensive. But so I think that there's some work that can be done there, but I wouldn't, I don't, again, this is your committee, and we'll live with what you do. And but I think that there's some fair argument not to totally extinguish all of C.
Any closing comments you'd like to make, Mr. Wetland or Director? Either one?
Madam Chair, thank you. I'll be brief, and then I would, of course, if Director Nesvik has any comments, I'll leave some time for him. I think there's two important points here to focus on. And the first, Mr. Harris noted that this language, when you read through it, the perception of it is what has caused questions. And I think that perception piece is important here. The language itself does not, I don't believe it requires, even in an agreement, a tribe to be subject to the Game and Fish Commission's regulatory system. Under that subsection, and this is just an example, I won't walk through every section, but under subsection C, when it goes to Romanet 6, subsection D, it says set appropriate quotas, daily limits, and possession limits that do not conflict with quotas, daily limits, and possession limits set by the commission. So the standard there is, do they conflict? It's not, are they the same as? And I think there is room in that provision to negotiate and talk about what is that space and what does it look like? And I think that's the intent of most of the provisions in this bill. Enforcement of an off-reservation tribal hunting code, there's the opportunity to talk about a state game warden enforcement, but nobody is bound by that. And I think the reason we have that space here for both sides to negotiate is, to Representative Larson's point, there's non-tribal hunters that the governor has to consider in the legislature. There's tribal hunters, there's the legislature, there's Wyoming tribes, there's non-Wyoming tribes. I mean, I'm the son of 2 lawyers, and I've lived with threading the needle growing up my entire life. And I will say this is an exercise in threading the needle the best way we possibly can. And I would just say, in terms of the perceptions of what this might say versus what it does say, at the end of the day, this bill does not bind a tribe to anything. I understand, though, very much so, for a tribe, this is an important, delicate issue for them and their members. I do not want to minimize that in the slightest, and that's why I understand and appreciate the strong argument about this bill. I guess the last point, too, in terms of worries about overregulation by the state, any agreement, and this is common in MOUs, MOAs, whatever you want to call them, they have a termination provision. And those termination provisions can be anything from termination without cause and 30 days notice to termination with cause to termination with mediation. There can be an easy escape valve if a tribe wants to negotiate that. So all that to say, this is threading the needle. This is a delicate issue. I want to be sure to convey that the governor respects each tribe's opposition or support to this bill, whatever it may be. But we do stand by this work and believe it provides tribes the ability to negotiate openly and to just say no if they don't want to.
Thank you very much. Director?
Yeah, thank you, Madam Chair, members of the committee. I'll be brief too, but I think Mr. Wetland summed up well some of the components of the bill that are important here. I think that there's one place where there's a lot of common agreement, and it's really a values issue. And you haven't heard anybody here testify today. You haven't heard the Supreme Court speak negatively against this. You haven't heard the proponents of the bill speak against this. And that's, everybody agrees that there's a need for regulation in order to have healthy, viable wildlife populations. You know, one of the unique conversations we had that was pretty powerful to me was early on when we met with Eastern Shoshone. We talked about how in America in the 1930s, our wildlife populations in this country were decimated. You can imagine, think of the state of Wyoming only having 10,000 pronghorn antelope. And because of the North American model of wildlife conservation and sportsmen and women and the government deciding that regulation was really important, wildlife populations rebounded, and now we have a tremendous wildlife resource in the state of Wyoming. Very, very similarly, the Eastern Shoshone relayed to us the situation on the Wind River Reservation in the 1970s, which was similar, and they implemented their game code and science-based wildlife management. And today they have a tremendous wildlife resource on the reservation that they all enjoy, and they talked a lot about that. So I think the bottom line is there's agreement around the need to have conservation. The Supreme Court even said that. They said you need to take this back and you need to figure out what that looks like in Wyoming. Again, this effort was intended to do that on our terms between two sovereigns. Actually, not just two sovereigns. The bill says tribes between multiple sovereigns, and not allow that to happen in the courts, to do it on our terms. So I would stand for any other questions, Madam Chair.
Questions for the director? Okay, Senator Jones.
Do we have any tribes that are in favor of this bill currently?
Director? Or Mr. Wetland?
Madam Chair, Senator Jones, at this time, I don't have a tribe with an affirmative statement to me that they support this bill. One could come in the future, but we don't have one right now.
You follow up? Oh, good, okay. With that, unless there's any other testimony, then I think we will close testimony. Thank you very much, gentlemen. Appreciate your testimony today.
Thank you, Madam.
You betcha. Yeah, thank you. Okay, we've heard lots of testimony today. What is your pleasure there, committee?
I'll move the bill.
Okay. Bill's been moved by Senator Baldwin, seconded by Senator Guru. Let's go ahead and take a look at it. Oh, Senator Baldwin, you have a comment?
Just a comment without going item for item. I know that we all have a handout of proposed amendments or suggested amendments by Senator Ellis. And I guess to this point, and I would address this point to one of our speakers who said, it hasn't gone before the people. And I guess the part of that amendment is I'm looking on page 2, where Senator Ellis has suggested perhaps being ratified by the majority of both chambers before it goes into effect. And I think that has the effect in our tribe, if you will, of that's our putting it before the people. Do our resident hunters, do our non-tribal hunters, what do they think about it? It takes us a chance. I think that would be an important amendment. I would not be in necessarily agreement with taking out everything else because it provides a means for negotiation. It gives them substantive things to talk about, but it's not going to go into effect unless there's an agreement with all those tribal members, with all of the non-tribal members, if you were. And the other important part that I saw of her proposed amendments was at the very end of the bill, to a conversation to identify and define unoccupied lands and conservation necessity. I think that's important that we include that. So I don't think that I would remove all those things. I think they're important parts of the conversation, which has been talked about as we heard from May to October, et cetera. They're part of the tool, and I get that they do sound condescending to a point. I get that. But I think they're an important part of the conversation, and that's all I'm going to talk today. And thank you, Madam Chairman.
Thank you. Go ahead, Senator Ellis.
Thank you, Madam Chair. So I just kind of made some notes on a bill and handed it out to my colleagues for their consideration, and it essentially would remove all of Section C. It would remove or alter Section 2, and it would instead have, the Game and Fish should report to the TRW committee with recommendations to define and identify unoccupied lands and define conservation necessity by a certain date, maybe October 1st, 2024. And then it would delete Section 3, and then Section 2 would be the effective date. The note I put in there, though, was, the authorization would be repealed by July 1st, 2027. I think part of the reason that we have this bill is because we're dealing with a specific governor who is really engaged in working on this. So by doing 2027, if the governor were to say, We're making progress. We think we're getting there. Let's continue this on. They could always ask for more time to get an agreement ratified. So I think a sunset's important to just drive that urgency. In deleting all of section C, though, I think one trade-off in trying to think of our ability and our interests as a legislature would be that any agreement before it takes effect would need to be ratified by the majority of both chambers of our legislature before it can take effect. And so all of the things that are contained in C could be negotiated and included in the agreement. They're just not there as the starting point for negotiation. Looking at where to draw the line on what to keep in there and what not, I do think that Romanet 6 says the tribe agrees to align its hunting, fishing, and trapping seasons with our hunting, trapping, and fishing seasons. To me, what if the tribe wanted to start that a week late, a week earlier? Some of that I just think is, why is that there? I get that was discussed at one point. So I'm trying to get there. We heard significant opposition to this bill. I still think it's valid and important in trying to find a solution and to signify that we're not going to continue to litigate or seek litigation that we do, or maybe we do, but this is, an alternative to that we, would signify to people that our legislature supports it and our governor in doing this work. So this is a really tough issue, and I don't know the best way to proceed. This is just a thought that I thought might get us a little closer, knowing that it still probably wouldn't be supported by the vast majority of tribes that testified today. So we can work it, we cannot. This is a tough one.
So Senator Ellis, would you like to make that motion now, or do you want to work the bill first? What's your pleasure, committee?
Madam Chair, I'd move my amendment. I'll move the whole thing. For the people listening, it would say on page 2, line 7, after the word tribe, insert as provided in WS 20-5-202A Romanet 6. That's the definition of a federally recognized tribe. I would delete the word on line 7 and insert off reservation. Leave the word hunting. Delete fishing. On page 8 or line 8, delete trapping or gathering. Before the word right, insert the word treaty. Change the word right to rights, and then strike the rest of that line. On line 9, strike or other recognized federal right, and just leave on lands located within the state. So the paragraph would read, the governor on behalf of the state is authorized to negotiate and enter into an agreement between the state and a tribe as provided in the statutory citation concerning off-reservation hunting treaty rights on lands located within the state. Going on to paragraph B, that paragraph would read, any agreement executed under this section shall be in writing, comma, delete the word and, signed by the governor and the governing body of the tribe, comma, and ratified by the majority of both chambers of the legislature before the agreement shall take effect. I would delete all of section C. Going through page 4, onto page 5, delete all of D, delete all of E. And in its place, I'd insert a new section C that said this section is repealed effective July 1st, 2027. And then I'd have a reporting requirement on the bottom of page 5. The Game and Fish shall report to the TRW committee with recommendations to define and identify unoccupied lands and define conservation necessity by October 1st, 2024. Going on to page 6, I'd delete all of section 3. And then I would renumber the effective date and just have that be section 2 instead.
Discussion on the amendment? Discussion? Senator Gruhl?
You don't have to take it.
No? Thought you had something to say, no? Go ahead, Senator.
Thank you. I wonder if the bringer of the amendment would be amenable to a division. The division being the first division would be on page 2, all the language you proposed from starting on line 5 down through line 15. That's one division. Then the second division would be the rest.
Madam Chair, we're fine and happy to take these in chunks.
Okay.
That's your, okay, great. Well, let's go ahead and take a vote on the, oh, excuse me. Yeah, do you want to discuss the division first?
On and for Division 1.
Okay,
I think that those are all, first, before I started with that, let me just say, I've learned something probably very obvious to everybody on the committee today, the tribal committee, and this committee too, that I didn't know, because I don't deal with these issues that often. That how much at times the tribes, our tribal friends, seem to feel they're different than us, how much they are the same, especially about the Wyoming legislature. They're fiercely protective of their turf, and that's good. So are we. We're distrustful of those above and around us, as we are naturally, of what their intentions are and what they aren't. We feel that way a lot. I hear that a lot in talks that we have on our floor. And it kind of came to light in the testimony I heard. Although I didn't hear is I heard, and former Representative and Senator Harris, good friend of mine, and I did not know those other folks, but I know they're serious people. But I also know they're not officials of the tribe who we didn't hear from. I heard from them in a letter dated January 12th, and then heard that letter doesn't apply anymore. I don't know what their position is now, except that the letter that they sent on the 12th doesn't apply. So that's why I like the language in the first division. And then we'll talk about the second. So on and for the first division.
any other discussion on the first division, Division 1? Okay, let's take a vote on that. All those in favor of Division 1, lines 5 through 15, please say aye.
Aye.
Aye. Any opposed? Okay, that division has been passed. What's your second one?
I'll leave that to others to start.
Okay. You're okay with everything else? Senator Ellis, anything else then? With the rest of your amendment?
No, Madam Chair, I'd say that deleting section C, I'm trying to get to the balance of wearing both hats, and I don't know that that's always possible, but the ratification by both chambers of the legislature was intended to replace C. Those, to me, go hand in hand. I think if the governor and a tribe are able to enter into an agreement, they would come to the legislature and go through it paragraph by paragraph, and it would say things like, here's where we agree on, their hunting season is this, our hunting season's this, here's how they come together, or we've decided to align them, however that negotiation might work out. So I think everything that's on 3 and 4, to some extent, maybe it isn't collecting all harvesting data, maybe it's something else, but here's how we think it's going to still benefit the tribe and the state. I think all of that would then come before us, and the legislature would vote it up or down, and this would be a huge lift. But I think it would be up to the governor to exercise a tremendous amount of leadership. I think if the tribes supported it, we would hear that support. And then we would, as legislators, hear from our constituents, and then it would be ultimately decided on us to either vote it up or down. We wouldn't have the ability, I think, to unilaterally impose anything. It's just either we ratify the agreement or we don't. So that was intended to cover C to some degree, but not have it be prescriptive at the outset. Let the agreements organically happen between the parties. That said, like I said, we heard the testimony, we heard it loud and clear. This has not been fun to work on.
We do have bills that are not really fun. I have to admit that, yeah. So let's go ahead and take a look at Division 2 then, which would be deleting C and adding the rest of the language that Senator Ellis has on Section 2 and making a new Section 2, I take it back. So let's go ahead and take a discussion first on that part. No? Discussion? Senator Grew?
Thank you, Madam Chair. On and against Division 2. This goes back to just a testimony I heard, threading the needle, to the comments from the first floor. I think I didn't take, and I understand, when I say once again, legislature and tribes are a lot alike in these issues. I didn't take the offense that I heard from some of the testimony. I felt like we were just trying to put in sideboards. Can they be thrown out? Yes. Can they be changed? Yes. That's up to the decision between the parties entering into the agreement, if they choose to enter into any agreement at all. That was the other part that I heard loud and clear. Maybe and I guess that's what I'm trying to parse out. Maybe the language is fine. It's just before its time, as far as at least one of the parties is concerned right now. Does that mean it'll always be that way? I don't think so. Does that mean even that may change in short order with the leadership of the tribe? Maybe so. Maybe not. If it doesn't, that's their sovereign right, and I agree with that. And so that's why I think if we're going to enter into an agreement, it needs to have something to, and we as a legislature need to have some sort of input to that, not just the end too as well. So that's why I'm for it, not to say anything negative about any of our friends. I don't think, I know that wasn't the intent of the committee, and I don't think it's the intent of anyone else. So if it was perceived that way, so be it for now, and then maybe we can work on that as a second phase. So on and against.
Okay, Senator Baldwin?
Likewise, I'm on and against, and I would express some of the similar comments, is that the final agreement that comes out may look nothing like this, or indeed there may not be an agreement at all. But I think that section C, in all those divisions 1 through 7, I think they provide a framework, and it's a framework, a starting point, and I think it's a starting point that's already been discussed. And I think that taking that framework out puts them at a disadvantage, and who knows what may happen. But I think that framework's important. It may totally change. It may not look like this at all when it comes out of the report. But I would be in favor of leaving it in to provide that framework and to go from there. So I would oppose this half of the second division.
Any other comments? All right, let's go ahead and take a vote on Division 2 of this bill. All those in favor of that division, please say aye.
Aye.
Aye. Opposed?
No.
Okay, that division has failed. Back on the bill. No, that wasn't. That was a very vociferous aye, So with that, is there anything else, any other changes or anything else we need to do with this bill?
Madam Chair?
Yes, go ahead, Senator Ellis.
Madam Chair, I would move then to get rid of the language that we just adopted on page 2, line 14 and 15. I think, to me, these sections always work together. So it would go back to the language that's there. Any agreement executed under this section shall be in writing, signed by the governor and the governing body of the tribe. If the agreement has all those sideboards, then you don't need our ratification. I think that's how that was contemplated before.
Okay.
That's my motion.
Discussion on that motion. So this would be on page 2, line 14. You would take out "and ratified." Just take that language out completely. And the "and" would stay in, as well as the comma there. So any discussion or issues with that? Okay, second on that. Let's go ahead and vote on that motion. All those in favor of that latest motion by Senator Ellis, please say aye. Aye. Any opposed? Okay, that will stay in that language.
Madam
Anything
Chair?
else? Yes.
I move on page 5, line 17, insert a new paragraph F, and just say, it would say this section is repealed effective July 1st, 2027. I think this was brought by a specific governor. If the governor is making progress and this has been an effective tool, then we can always look at lifting that repealer date. But you might have a new governor who wants to take office and doesn't share the same position and passion that our governor does. So just this is meant to be out of respect for our governor. I think July 1st, I picked that and thought about, do you extend it to December 31st, 2027, which is closer to when the governor takes office? Actually, maybe that makes more sense now that I've gotten rid of some of this. How about instead of July 1st, December 31st, 2027? That's the motion.
Did you get that, Doreen? Okay. All those in favor of December 31st, 2027, please say aye. Aye. Opposed? Okay, that is also passed. Anything else? Okay, all right, let's take a roll call vote then, Doreen.
Thank you, Madam Chair. House Bill 83, tribal agreements to hunt and fish, Senator Baldwin.
Aye.
Senator Ellis.
No.
Senator Guru.
Aye.
Senator Jones. And Chairman Schuler.
Aye.
Ma'am, we have 3 ayes and 2 noes.
Okay, that passes barely by the skin of his nose. Excuse me? No, it didn't take any time at all. We zipped through things pretty quickly. Thanks again for all of you that testified.
Who would like to present?
We'll look at one of the sponsors.
Yeah, we'll talk to one of the
Thank
sponsors,
you.
yeah. So we still have one more bill. I think we could get a start on it. Director Hanson, are you okay if we start with it? We may not be able to get through it, but let's get a good start on it anyway. House Bill 99, Property Tax Refund Program. Welcome, Director Hanson, and sorry about, we should have put you first. I have a feeling yours is going to go a little quicker. Who knows? Who knows? Who knows?
Chairwoman Schuler, members of the committee, Brenda Henson, Director of the Department of Revenue. This does seem like a little more lighthearted topic. So with that, in the interest of time, I have provided kind of a handout, more included a lot of the history. And in the interest of time, I'm going to focus on the bill, walk through the bill, and my comments will be specific to this last document that's in your handout, and that gives some updated information. So with that, just as a reminder, this was an interim topic for 2022, and this was a joint revenue bill. A lot of discussion. This is a program that has been in place since 2003, as far as the Department of Revenue administering it. With me today, I have Christy Urich. She has worked on the property tax refund program since it went up to the Department of Revenue. Just a reminder that taxpayers can apply for this both right at the Department of Revenue or at their local county treasurer's office. And then the treasurers submit those applications to us. You'll find within the packet that it was funded for 2021 refunds and tax year 2022 refunds during our last current biennium budget. It was funded to the tune of $3 million. You'll see in the documentation that we sent out a little over $1.8 million for 2021 tax refunds. Historically, we've never had in excess of $1 million. So as you can see, we had a lot more taxpayers that took advantage of the program this past year. And I think that we will, under current law, see a lot more people taking advantage for 2022. With that, you'll also see some history of what the median residential property tax amounts were. And there were 3 years in the past 10 years that it was not funded by the legislature. So when we look at this program, we'll just start again, House Bill 99. I'm looking at the engrossed version. Just turning to page 2. The first language in the bill would be to clarify that it's the owner or an immediate family member that occupies the residence. We had some testimony in the interim that some of while they're the taxpayer and it's their household income that allows them to qualify for the benefit, that they didn't actually live in that home. They had a family member, a child, or a parent that live in the home. And so that's where that language comes from on lines 6 and 7. Moving down to lines 16 through 19, That was language that was in a bill that was passed last year. Just quickly to remind the committee that Senate Bill 19 was passed in 2022, and that was a county option refund. Within that language, there was this 9-month requirement, and the interim committee wanted to mirror those bills, so they pulled that language from the county option program and put it into the statewide program. On page 3, this bill would change the income criteria that right now it states that the income total household income cannot exceed 3/4 of the median gross household income. And for this portion of the statute, I turn your attention to this document that I have provided. For 2022, we were able to get the household income numbers from economic analysis. 3/4 would be that blue column. If the language changing it to 125% was not passed, the pink column would be what those household median income numbers were at 125%. So this is purely for information for the committee as they consider that change in this bill. Turning on to page 4, there was an amendment in the House that talked about unless the person's tax liability is greater than 10% of the person's household income, no person should qualify for the refund on the asset test. So that 10% of household income is only applicable to the asset test. It just says that if your assets are in excess of this change, the $150,000, as long as your tax liability exceeds 10% of your total household income, that asset test would not need to be met. And I believe there'll be some testimony from the person that brought that amendment. Moving down to what is capital C on line 13 and 14, the Revenue Committee asked that the refund granted in this program shall not exceed 1/2 of the median tax bill for the county where the property is located. That dollar amount is on the second page of this handout. And what this does is it continues to say that the maximum refund is that 1/2 of the median. But if your tax bill is less than, let's say it's, your 1/2 of the household median, look at Albany County, for example, 1/2 of that median tax bill was $934.60. If your tax bill was less than that median amount, then you could get up to 90% of your tax bill. So it really focuses relief for those lower valued properties while still keeping in place the 1/2 of the median as a maximum. The other portion of this bill was to blend the statewide program versus the county option program. So paragraph F that starts on 21, it just basically states that when the Department of Revenue completes the administration of the statewide program, that we will provide a report to the county treasurers that explains which applicants were granted an exemption, a refund, and which were denied. We do that currently, but this is just to codify it in statute. On page 5, line 4, that is the beginning of the county option language in statute. Again, 2022 Senate File 19. And what we've done is, I don't believe it was ever the thought process when the county option was contemplated last year that both programs would be funded at the same time. The idea was the counties wanted the opportunity to fund the program locally should the legislature not fund the program on a statewide basis. And so as the county treasurers and the Department of Revenue discussed this, we found that it was going to be very confusing to the taxpayers to have these programs simultaneously being administered. So in conjunction with the county treasurers, what we've done is we have delayed these dates for the administration of the county option. And you'll find on line 13, we changed the June to September. That means that the statewide program has been finished up. They have an idea of our report that tells them who qualified and who did not. Then on page 6, we just incorporate the same language to ensure the county option program mirrors the statewide program. And that's also on page 7. Again, just mirroring the language. But then on page 8, line 5, we changed the date when the county treasurers would be sending out refund checks from September 30th to December 30th. So again, just trying to ease the confusion for the taxpayers and to ensure that there's a provision in the bill that says the statewide program and the county program, that at no time will a taxpayer receive more than 100% of what their tax bill was in the first place. And so with that, I would be happy to touch a little more on the appropriation as it stands, or I'd answer any questions. I know we're short on time.
Questions, or do you want to hold the questions until, would you be okay coming back Thursday and then we could?
Of course.
I know I have a few questions for you, and I don't know about the rest of the committee. You guys be all right with that? I think we probably have some folks in the room that would like to testify. So if we put you up first on Thursday morning, would that be all right with you?
That will be just
Director?
fine. It also provides the committee a little more time to review the documents that we've provided. We do appreciate your consideration this
I
morning.
appreciate that. Thank you so much. Let's go ahead then, and we will save testimony on, and we'll bring you guys back first, and then we will open it up to the public. So thank you,
Thank
and
you.
sorry about the time constraints. Appreciate the information. Thank you. With that, I guess we better adjourn because we're running a little bit late to get back to our hallowed grounds. So, thanks.